Welcome, welcome, welcome to Beyond TM, Protecting Your Brand with Trademarks, hosted by my law firm, Legacy Legal and Consulting Firm, and myself, Shayla Jackson. Oh, okay. So let's get in. Here's our agenda for tonight. We are going to first start off with defining what is a brand. Then we're going to talk about the legal definition of a trademark, the difference between a brand versus a trademark, how trademarks are born, strategies to create a strong brand that can be trademarked, mistakes to avoid when creating a trademark ready brand, steps to move beyond TM, the power and the benefits of a federal trademark registration. And as a bonus, if you stay with me to the end, you are going to receive some brand protection strategies that go beyond just trademarks. And I have a surprise gift for the winner of our challenge tonight. So welcome, welcome, welcome. Some housekeeping. I want you to grab a pen and paper or something to take notes with and lock in with me for the next, I put 90 minutes, but baby, it's really 2 hours, just the chock full of information. Now, if we get out in 90 minutes, that's good too. Just to let you know, hold all questions until our Q&A section. Okay, so write your questions down and we're going to have a Q&A session where you can ask your questions. This is not a how to trademark or DIY training. So we're going to go over the process of trademark registration, but I'm not teaching you how to actually file your trademark here. Prepare to participate in tonight's challenge, and there is movement required. So just get ready and engage and talk back to me in the chat. Engage and talk back to me. I want to be able to talk with you. There is a no judgment zone here. So you are smart. Ask your question. You didn't go to law school. You might not even known about trademarks until you came into this class, or you know a little bit. So don't worry about your question. Just ask it. It's my responsibility to figure out what you're trying to say and help you come to the right question, but also answer it. The replay will be available for 2 weeks. And so my gift for those that stay to the end, there's a gift for you. My gift for you is a surprise, but I believe it's going to help you based on what we are going to cover tonight. All right, so a little bit about me, because you are here. You probably have never met me before. Some of you have. I am Shayla Jackson. I am a trademark and business attorney, and I'm also chief legal counsel for some of my clients. I founded my law practice in 2021. So that's when I started Legacy Legal and Consulting Firm. But I've been licensed to practice law for 10 years now. Actually, this year will make 10 years. 10 years since I graduated from Georgetown Law, and 10 years since I passed the bar exam. I also graduated from University of College Park. I don't know if we got a couple of folks who register who are from Maryland. So go Terps, okay? I'm a Maryland native. But I'm not just the CEO and founder of my law firm, Legacy Legal. I'm a business owner too. So many of you who are like, I don't know about trademarks, you are not alone. I'm not new to business. When I first started my business, I remember Googling, do I start an LLC? What's an S Corp? And every article I went through, I got more confused. And now that I'm on the other side, I look back and I am so grateful I did not get sued. I'm so grateful there were no conflicts with that DIY contract I tried to draft up myself, because I didn't know what I was doing, but I knew I needed it. I just didn't have the education. And so tonight, I'm hoping you get the education you need in this webinar to go beyond TM. I am also the author of my book, Build a Legit Business, which is available on Amazon. And when I first started out, I didn't start out with my law firm. When COVID hit in 2020, I asked myself, what makes me different in the marketplace? What can I do to stand out that everybody else is not doing? And I realized I had a law degree. Not only did I have a law degree, but I have a teaching background. I taught law to DC high school students and some individuals in DC jail, as well as to youth, juveniles on probation in DC. Now, the way that I taught law is not the typical classroom. Let me just give it to you. Y'all, we didn't look. You didn't go to law school. You wouldn't start understanding if I just started saying indemnification and breach of contract. That's just not how we work. And so the way that I was trained was in a student-centered teaching, immersive teaching, where we engage you with where you are. So you're gonna hear some language from me that is not the typical lawyer. I want you to cast off what you think an attorney should sound like and look like, okay? Because the teacher in me and how I learned to teach, but I also spent a year at Georgetown Law teaching law students how to teach. And because of that, you are going to see some things and hear some things that are strategically placed and strategically said so that you understand. Okay, so that's a little bit about me. If you want to learn more, you can simply Google Shayla Jackson and put attorney behind it. There are more Shaylas popping up around the world. And I've been featured in the Baltimore Business Journal, Canvas Rebel, Voyage Baltimore as a hidden gem. And I've also had the privilege of speaking for Gartner, Maryland SBDC, as well as other SBDCs around the country, and as well as Maryland Innovation Center and other organizations as well. Okay, so that's a little bit about me. Now, for those of you who are here, take a screenshot of this screen. Take a screenshot of this screen. Take a screenshot of this screen. Okay, this is for you to stay in contact just in case you leave early. Take a screenshot of this screen. All right, hopefully you took a screenshot of this screen. I'll have it again at the end. Now, before we jump into tonight's materials, I have to provide a legal disclaimer. This webinar is legal education only, and the materials or answers to questions should not be considered legal advice. Now, if you need legal advice, especially when it comes to trademarks, you can schedule a discovery call with my law firm to discuss your legal matter, no matter what state you are in, because trademark is federal law. Now, by you being here, there is no attorney-client relationship between me or you or your business and my law firm. And by your investment or presence in this webinar, you are solely responsible for all actions you take on the information you receive tonight. Now that we have gotten that out the way, let's jump into tonight as we talk beyond TM, protecting your brand with trademarks. So I want to ask you a question. And I want you to think about your brand investment. How much money have you invested in your brand today? How much money have you invested in your brand, your business, from design, from products, from services, your website? Estimate how much money you have spent. And I also want you to tell me how many years you've been in business in the chat. How much money and how many years you've been in business. I want you to put it in the chat. Share it with me. Talk back to me. Okay, I'm interactive, y'all. You got to talk to me. 5 years or 5 figures and over 8 years. 5 figures. That's 5 figures, y'all. That and over 8 years. All right. Anyone else? How much money have you spent investing in your brand? And how many years have you been in business? Come on, y'all. Don't be shy. There's no judgment here. I want you to write that down in the chat. Share it with me. Okay, $500 as of now and just starting. Okay, now I want you to think, how would you feel if you could never use your brand again and you had to start all over from scratch? How would you feel? I want you to drop your answer in the chat. Oh, we got the vomit emoji immediately. the vomit emoji, right? Because you invest 5 figures, you're gonna feel some type of way with you if you have to start over. Disappointed, absolutely, absolutely. That we would feel some type of way. And so that this is the reality of it. And so this is why we're here, because look, we don't want to have to start over. We want to know exactly how to protect our brand so that we don't have to start over from scratch and all of that money we invested just is out the window. And so one, understand that when it comes to brand protection, this is how I teach it. You can't even get to the protection part until we get to the brand part. And so with brand protection, it does not start with a trademark. It doesn't start with trademark registration. You know where it starts? It starts before it. It starts before you ever start branding. Brand protection starts before you ever start branding. And so, what is a brand? A brand is defined as the public image, reputation, identity for a person, business, or product or service. Let me say that again so it's clear. A brand is the public image, reputation, and identity for a person, business, or product or service. It is how we are perceived in the marketplace, how others perceive us. What's the image we project? And so a brand is a combination of design elements, your identity and reputation, which includes your logo, your brand colors, your fonts, keywords that you use, your story. It's the aesthetics, right? The visuals, your voice. What's the brand voice? The designs that you use, the images that you use, and the quality of your products and services, public opinion and perception, as well as your reputation. Look, we have all gone to restaurants and they had raving reviews or somebody recommended them. And so we went. And then when we got there, we said, what? This? No, either the food was bad or the customer service was horrible. And we said, never again will we go back. How many of you have had that experience? Never again will I go back. That that is a part of the brand, the reputation. You had a bad experience and now you don't trust that brand. And so when you understand that a brand is a combination, it's not just the visuals, it's also how you operate your business, the reputation that people think, what they understand, the perception they have of you as a brand in business. And so a brand helps you stand out in the crowd. If your business is the same as another business, it's the branding that will make you stand out. Now, let me go back for just a moment because I said brand protection starts long before the branding process. And the reason why is because brand protection starts with you being equipped with the right knowledge. If you don't understand how to create a brand that stands out, or you rely on someone else to create your brand for you, you never know if you're putting yourself in a position for your brand to actually be ineligible to be trademarked or protected under trademark law. That's why you being here is so important, because brand protection starts with you. So I want you to look at the screen and see all of these products. All of these you see, you probably are familiar with them. You've seen them before. I just used Vaseline and Dove today. And so I'm going to ask you, what do you think all of these have in common? I want you to drop your answer in the chat. And don't worry about being wrong. What do you think all of these have in common? Someone said trademarks, right? The obvious answer. Brand, okay. Anybody else? Look, and for those that join, welcome, welcome, welcome. I'm interactive, so you can't just sit behind the screen. Come on and chat and indulge and get engaged in the chat. Talk back to me. Strong logos, reputations. Okay, you ready for the answer, y'all? You ready for the answer? The name of the brand is practically synonymous with the product. Those are all good guesses. Here's what they all have in common. There are multiple brands owned by one company, whether they were brands owned in the past or currently. One company called Unilever. Multiple brands, multiple products, one company. Now, the company has subsidiaries and things because the company is originally, I believe, in the UK. So they have subsidiaries in India. They have subsidiaries in the United States, but multiple brands owned by one company. So when we talk about the difference between a brand and a business, I get this question that, what's the difference? The difference is that a brand, again, is the reputation, but the business is the entity that is engaging in the activities, the operation of running a business for income, revenue, and preferably profit, that the business is in the business of actually providing products or services. And so a brand is not a business, but a business, the business name can be a brand. I hope you're catching this. A brand is not a business, but the business name can be a brand. The business can have a brand. The business name can be a brand, but the brand is not a business. Now, when we talk about trademarks, a brand is eligible to be trademark, but not every brand is a trademark. And so a business name could be a trademark, but not every brand, not every name is a trademark. So you can have a brand, but not a trademark. And that's why it's so important that you understand what we're going to cover here tonight to go beyond TM, because there are many people, by the time they get to me or another trademark attorney, they want a trademark and they don't realize they have a brand, but they do not have a trademark. And so what is a trademark, right? We're talking, what is a trademark? So I don't know about you, but when I was younger, my family and I used to go on road trips. We would go from Maryland to South Carolina to visit family down there. Now, my family was old school. That meant that when we got on the road, there was no potty breaks, okay? Now, when I'm talking about no potty breaks, I'm talking about when if you really, really had to go, they were so old school that they pulled on the side of the road, opened the doors, and I remember having to squat to pee. OMG, cars running, driving past, I hope nobody see me. That's how old school they were. Baby, once we got on the road, we won't gonna stop one time to get some food. And we're gonna head on that 6-7 hour drive until we get, look, Val, you can relate, right? Look, okay? And so there were times where you would see in the distance the signs, a potty break is coming up on the road. I don't know about you. And so how many of you have been on the road driving and in the distance you see this yellow M? What you know that as? What do you know that as? When you're you're driving and you see it, you're coming up on it and you see this yellow M in the distance. What do you recognize that as? That's right, McDonald's. That's right too, Val. A potty break. I recognize it as a potty break. And so, look, that's not it. Now, when you hear this, I want you to tell me what immediately comes to mind in the chat. All right, I'm getting ready to play it. You ready? Uh-oh. Got to turn my volume up. Hold on. I'm going to turn my volume up so you can actually hear it. All right, let's start this again. When you hear this, what immediately comes to your mind? What comes to your mind when you hear that? Oh, you can't hear it. Oh, you can't hear it. No. That is not good. Oh, what's going on? Oh, no. It's too soft. Okay, let me see if I can put it near my speakers because I tested it out and it was working. Okay, let me try this again. Can you hear it now? Not, oh my goodness. No, they did not turn my thing off. Y'all, I am so sorry. I had it all planned out. And the thing is I did this in another training and it worked out. And so I may have to sing it for you, okay? Whew, don't judge me. Don't judge me. Dun 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 boom dum 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 dum. I don't know if I did a good job or not. Ooh, if you could try, what do you think that is? Okay, you're not familiar with it. Okay. Anybody else? If you could try to guess, what you no. Look, I did a poor job. Look, y'all, it happens. It is actually look, don't laugh at me. It's actually the intro for Law and Order. Look, Val, you get Law and Order. Yep. Mm-hmm. Y'all remember that dun dun sound? Dun 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 dun. Dun. Look, y'all, I tried. Okay, I don't know why it didn't work here. It worked last week or so. But anywho, that dun dun sound is how we recognize. You could be in anywhere in the house, and the moment you hear that dun dun, and it start playing, you would know Law and Order is on the TV. That is the power of a trademark. You recognize it. You know it when you see it. That is the power of a brand that operates as a trademark. It's a signature. So, a trademark, let's define it. A trademark is a mark that acts as a source identifier on a product or service that is used in commerce. The mark must be distinct and not confusingly similar to an existing mark. Okay, so it's a mark that acts as a source identifier. We know the source of the product or service that is on, and it has to be used in commerce. We're going to get to that definition because that's a legal definition. And that mark can't just be any mark. It has to be distinct. It has to stand out, and it cannot be confusingly similar to an existing mark, because trademarks want to make sure that there is no confusion about the source of products. That we know that when we see this mark, when we see the bitten apple, we know the source of that product. When we see the Facebook logo, we know the source of that product. We're not confusing it with Google. We're not confusing those things. When we see McDonald's, we know McDonald's is not Burger King. So we want to make sure that consumers, this is what trademark law does, that consumers are able to properly identify the source of a particular trademark when they see it, so that they know the source and the reputation of that source. This is how, look, we don't expect the same thing from Walmart as we do maybe Macy's or Neiman Marcus. We don't expect the same quality. Same thing. We don't expect the same quality from the dollar store as we do maybe Five and Below or Walmart or Target or any other retail that's more up on the other end. So there is a difference. So a trademark or trademarks are not created through trademark registration. I don't know if you knew that, but trademarks are not created through trademark registration. There are many who think if I apply for a trademark and I get approved, now I have a trademark. You actually have to have a trademark before you even register. Your trademark will never get approved when you register it if it's not already a trademark. So trademarks are not created by registering your business name with the Secretary of State. It's also, yep, look, I hope you see why this is important. Your trademark are also not created by filing a trade name or DBA. It's also not created by securing your social media handles. It's also not created by purchasing your domain name. None of these activities actually matter to creating a trademark protectable brand. Now, it's important when you're trying to lock in your domain in terms of, when I say domain, I'm not talking about your website, I'm talking about your territory, right? You want to get your social media accounts. You want to make sure nobody can steal it. But none of that matters when it comes to creating actually a trademark protectable brand. So again, a trademark is a mark that acts as a source identifier on a product or service that is used in commerce. The mark must be distinct and not confusingly similar to an existing mark. So let's get ready to break this down, because a mark is born in the branding process. So when you're branding, when you're coming up with ideas for the names or your logo, this is where we are creating a mark. And that mark is what has the potential to become a trademark if it meets certain requirements. So we start with a mark before we ever get to a trademark. Now, what are eligible marks? What are marks that are eligible to become trademarks? We have names, slogans and taglines, logos, symbols. So let me go back. Names, Google, Ben and Jerry's. Slogans and taglines, just do it. You can have it your way. I was getting new glasses, buying new glasses this week, and I was in the store and they had a banner and it was nationwide. Can y'all finish it? Nationwide is, what's the rest of that? Nationwide is, come on now, come on, stay with me. Nationwide is, y'all know the rest of that. Y'all know the rest of it. On your side, yes, come on. That's a slogans, logos. So the bitten apple we recognize for Apple, the golden M for McDonald's, those symbols, colors, the Tiffany blue, Barbie pink, the John Deere green, the UPS brown, all trademark colors. Sounds, the NBC chimes is a trademark. Scents, things you can smell. Play-Doh has a trademark for its scent, for its dough. Shapes, the Coca-Cola bottle shape, eligible for trademark. Shapes. And then you have a combination or a composite. This is where you combine multiple of eligible marks to create a distinct mark that is all in one. So think, for example, you have a symbol and a name. Many of us do that for our logos. That's a composite. So all of these are marks that are eligible for trademarks if they meet certain requirements. So what are the requirements? I like to call it the Fab Five. And so a mark can become a trademark if it is distinct and not generic, descriptive, deceptive, vulgar, or profanity. Now, I'm going to define what this is, because I know you're like, what's generic? And hold on, what is this? I'm going to define it for you. I'm going to break. I got you, okay? Now, look, I told you guys I have a teaching background. One of the things with teaching is I'm going to introduce some things to you that you may not know, so you become familiar when I bring it up later. Okay, so a mark, it has to meet the Fab Five. So it has to be distinct. It has to be placed on a product and or service. It has to act as a source identifier. It can't just be decoration. It has to be used in commerce. That's a legal definition I'm going to cover. And it cannot be likely confused with an existing mark. And I referenced that. We have to be able to see, does it stand out? That if I see this, I'm not going to confuse it with somebody else. All right. So distinct. A mark has to be distinct. And so if it's distinct, what happens is this: there is a spectrum of trademark distinctiveness. And so whenever we are evaluating a mark, this is why when you go to a trademark attorney or you're asking questions, we can't just, you just can't give us a name. Okay, we're always evaluating a trademark in connection to a product or service. A name by itself means nothing. So What happens is when we evaluate the strength of the mark, what we're really evaluating is how distinct it is. Where does it fall on this spectrum? And so you have generic, which is on the weak side, meaning it's not distinct and there's no protection. And then as you move up the spectrum or scale, you get to more stronger marks that are distinct and they are protectable, meaning you have a better chance of getting trademark approval, better chance of getting your trademark application approved. Okay. So stronger marks on that end. Now let's break it down. Let's break it down. What the heck is generic? What's descriptive? What's suggestive? And what is arbitrary? And what is fanciful? So here is my chart. Okay. So when we talk about generic marks, we're talking about common words, phrases, or name for a product or service. So, for example, a dress for a dress shop. That's so generic. A car for a car shop. Shoe for a shoe shop. Gasoline for a gas station. Bicycle for a bicycle shop. You see how generic that is? Now, that is a weak mark, meaning it will never be a trademark. You brand a generic mark, you will have a brand, but you will not have a trademark. Now, when it comes to descriptive marks, this is where a descriptive mark describes the content, the quality, the function, or the specific characteristic of the product or service. For example, public storage for what? Public storage. Frisbee is one. Best Buy, the Best Buy. U.S. News. It gives us U.S. News. Vision Center. Hey, come get your vision checked. It describes what it is. Now, Frisbee is actually a descriptive term that acquired secondary meaning. It acquired distinctiveness by operation. So if you have a descriptive mark, it may start out as being ineligible for trademark protection, but because you have acquired it through use, people become more familiar with the name. It can acquire distinctiveness, meaning now you have moved from being unprotectable to possibly being protectable. Now, we move on to more stronger marks. These are the marks that have a greater chance of being protected under trademark law, as well as a greater chance at being registered with the USPTO as a federal trademark. Suggestive marks are marks that express or suggest an attribute or feature of the product or service requiring some thought as to the meaning. So I want you to think that these are marks that are more of a brain teaser. They make you think a bit. Examples of this is Burger King. Well, what is a Burger King? Whirlpool. Jaguar. Now, we know jaguars, they're animals. They are animals, but a jaguar is fast. And so we know that remember, we never talk about a mark or a trademark just separate. We always compare it to the product or service. So anytime we are trying to determine if a mark is strong, if it's generic, descriptive, suggestive, arbitrary, or fanciful, we're always looking at, okay, well, what is the mark being used on? What's the product or service? And so Jaguar is for cars. And so that brain teaser is, oh, you're trying to say the car is fast. Now, Netflix is another example of a suggestive mark, as well as 7-Eleven. Now, we're going to move on to arbitrary and then fanciful. These are the strongest types of marks you can create in the branding process, because a trademark is born in the branding process. It is not born when you get your trademark registration. You either have it or you don't. So arbitrary marks are strong marks and are protectable. These are marks that are known words. We know them, but they are unrelated to the product or service we use them for. So Amazon, there's an Amazon rainforest. But y'all, I just got my Amazon package today. We know Amazon as, look, 2-day delivery if you have Prime. So the name is unrelated to the product or service. Tide. We know Tide as talking about the tide has turned, but we also know it as detergent. Apple. It's a fruit, but not when it comes to computers. Snickers. You can snicker, but now we relate it to the chocolate bar. And then Dove. A dove is a bird, but it's also, look, it's one of my favorite soaps. And so, an arbitrary mark, when you're in the branding process, you want to think about arbitrary marks. It could be a name but now it's unrelated to the product or service. That's an arbitrary mark. Now, a fanciful mark is the strongest type of mark you can create. These are marks that are made up words. They did not exist in our dictionary or our language. So marks like Google. Now, it doesn't matter what browser you're using. Safari, you can be using Firefox. I don't even know whatever. I don't even know if they still have Netscape or whatever other browser there is. But you could be using any other browser. And guess what? Somebody will tell you, go Google that. Go Google. Google is a made up word. Adidas, Kodak, Rolex, Pepsi, all made up words. So this is the spectrum of when you are looking at your brand, looking at your mark, trying to determine, okay, is it protectable as a trademark? Is it protectable under trademark law? Where does it fall? But you never ask that question without also asking, what's the product or service? And so here is the way that I recently taught it so that hopefully this will help you. Is it plain? Does it explain? Does it make you think? Is it unrelated? Is it made up and new? Generic, is it plain? Descriptive, does it explain? Suggestive, does it make you think? Arbitrary, is it unrelated? And then fanciful, is it made up and new? Now, weak marks can never be trademarks. They can never be trademarks. So again, a mark, in order for a mark to become a trademark, it has to meet all Fab Five. So you can't just stop there. The mark has to be placed on a product and or service. So if you have a brand and you're selling a product, but it's not on the actual product or with the service, then you have missed the second prong of a mark being eligible for a trademark. And I mentioned it cannot be decorative. What do I mean by decorative? You put your brand on a t-shirt, that's decoration. It's not trademark protected. But if you put it on the tag, if you put it on the packaging, now that brand is operating as a trademark. And it also has to act as a source identifier. So that's what I just said. Okay. So it has to have a product or service. So if you create a brand, but you don't have a product or service, you don't have a trademark. You just have a brand. You have a mark. Now, y'all, can you name him? Do y'all know who he is? Do you know who he is? Because I've seen him in many movies and I still don't know his name. I still don't know his name. Anybody know who he is? You can take a guess. No, look, I'm gonna take it. Don't nobody know his name. Don't nobody else know this man's name. Look, look, don't nobody else know this man's name. Y'all with me. And I'm trying to recall it because it seemed like when they told me what his name was, I forgot it immediately. This is what you don't want to happen with your brand. That when people see it, they can't even name it. They don't even know what it is. We just don't know. Okay. And so you want to make sure that when people see your brand, they recognize the source, right? We know, we probably seen him in movies and we don't know the source. We don't know who his name is. We just, look, somebody was like, is that Dave Chappelle? We're confusing who he is. Who is this man? Okay, so you want to make sure that that brand acts as a source identifier. Now I'm gonna skip number 4 for a minute and I'm gonna go to number 5. And that is you want to make sure that your mark is not likely to be confused with an existing mark. Now, what do I mean by that? There's something called likelihood of confusion. This will cause your trademark registrations to actually get rejected. And that means that your mark is likely to be confused with an existing mark. So many people have seen the movie Coming to America. How many of you seen that movie? Anybody seen that movie? You seen that movie? You seen that movie? I've seen that. I've seen the original. Did I see the second one? I may have seen the second one, but I saw the original with Eddie Murphy. You looked it up, didn't you, Deborah? You go look it up. But his name is Bokeem Woodbine. Thank you for Googling. Yeah, okay. I'm probably gonna forget it again by the next time I teach this, but it's okay. Likelihood of confusion. So Coming to America, if you've seen that movie, in the movie, Eddie Murphy and the father-in-law, Lisa's father, works at McDowell's. And so somebody in California actually did a pop-up and named it McDowell's. And I don't know about you, but they sell burgers and they also have a sign, if you can see it, that says home of the Big Mick. What that sound like, y'all? What that sound? Y'all know McDonald's. What that sound like? That sound a lot like Big Mac. So the likelihood of confusion, it's possible that people could confuse the yellow M if they saw it with possibly McDonald's, and they are not the same. Now, the name McDonald's and McDowell's, maybe not so, but there are similarities that could possibly cause confusion between consumers about what the source is. Is this McDonald's or is it not McDonald's? Is this a spinoff of McDonald's or is this something else? So you don't want your brand to be confused with an existing brand that people begin to wonder, hold on, are you connected to them or is this something separate? You want your clients and you want your customers to be able to find you. Now, hold on. Can you, I don't know what's going on with Zoom. Hopefully, guys, I'm having just a slight technical difficulty with Zoom telling me it's waiting and not loading. So I'm not sure if you can see my slide. But if not, I'm just going to just share with you. And so trademarks, what they do is they protect consumers from confusion in purchasing products or services from a source other than the one that they intended. And it protects businesses' exclusive rights to their mark and protects their brand reputation, and profits. Now, I'm going to share a little bit, just share a little bit about, thank you for telling me you can see it. When I was in middle school, high school, we used to go up to New York a lot. And I don't know if you've ever been to New York, but they have these side places, those steps you can go into, these places that have these back rooms. And they would sell Prada, Coach, baby fat jeans. They would sell FUBU. That's, I probably sharing my age now, but they would sell these items. And I would get them, I would buy them, get my jeans, everything for a cheaper price than I would have paid for if I actually went to a Prada and Coach store. And so when we talk about protecting your brand, if they were just out there, there would be confusion about what's the source? Is this real or not? And so that's just an example of, people can take advantage, especially if you do well, and try to piggyback off your success. So again, anytime we talk about trademarks, we are always talking about a product or service. Now, likelihood of confusion. When we talk about likelihood of confusion and we talk about, remember your mark, is it distinct for the product or service, or is it likely to be confused with another? There are 45 classes of goods and services. When I say goods, I'm talking about products. And so trademark protection is limited to the class for the mark that cannot exclude others from, trademark protection is limited to the class for that mark. And so when you're in that class, you can't exclude others from using that same or similar mark if they're in a different class or a different trade channel, except in certain circumstances. So let me share with you how I just recently taught this. Is that when we talk about classes of goods and services, 45 classes, I want you to think of a grocery store. And you know how grocery stores have different aisles? Now, if you go into a grocery store you're not familiar with and you're looking for a product, what would you do? What would you do? Tell me in the chat. What would you do if you went into a grocery store you weren't familiar with and you were looking for a specific product or service, a specific product? What would you do? What would you do? Aside from asking customer service, you would look at the sign above the aisle. You would look at, and what that sign tells you exactly what's in that aisle, doesn't it? This is similar to classes in trademark. So I want you to think of trademarks like a grocery store. There are 45 aisles. Each aisle tells you exactly what's in that aisle. Now, you know, when you go in an aisle, you're not in the other aisle. And there are certain products that are near each other. So when you are looking at bread, chances are you usually are close to the dairy section. You're usually close to cheese because those are usually sold together. Now, when you're in the meat section, you're not near the bread section usually. They usually keep that separate. Same thing when you're going for produce, strawberries, that's typically closer to the front of the store. And then bread and the dairy aisle may be close by. Now, when you go look for toilet paper, when you go look for those things you need to clean your house, that's in a separate aisle. And then when you go look for drinks, maybe you like ginger ale. I love ginger ale. That's in another aisle, which means that when you are in that aisle, you are not in the other one. And so when we talk about trademark protection, it's limited to the aisle that you are in. Now, when we talk about trade channel, this is, are they being sold in the same trade? Are they being sold online? Are they being sold at a brick and mortar? Are they being sold through mass distribution channels? What is the way that the product or service is actually being traded? So when we talk about likelihood of confusion and how distinct the mark is, we have to identify what class does the product or service fall in. What grocery aisle are we in? Now that we're in the grocery aisle, now we can start looking at, okay, is this mark confused with your mark? And if it is, or if it's not, okay, are they being in the same channel? This is how we decide, is it confusing or not? Because there you can have the same name as someone else, but there's no confusion. This is how we have Delta Airlines and Delta Faucets. This is how we have Pandora Jewelry and Pandora Music. Different aisles. Okay, so there is no such thing as 100% exclusive trademark rights in every class, unless you are using the mark for every class. So if, again, you can't be in every aisle unless you are actually in every aisle. So the Fab Five, it has to meet all of these requirements. The last requirement that I want to talk to you about is used in commerce. It got to be used in commerce. And this is a legal definition. So to be used in commerce, thank you, Valerie. This makes sense. I hope, look, I know many of us, we go to sources online and we try to understand trademarks. And I hope this is giving you more clarity. I hope this is giving you more understanding of how you take your brand beyond just a brand and create a trademark. Because again, you have a trademark before you ever get a trademark registration. If you don't ever have a trademark, your trademark registration ain't gonna happen. So getting back to used in commerce. So used in commerce means a bona fide and actual use of a trademark in the ordinary course of business, trade. This is not a single or infrequent sales, but ongoing use in business. So this is established when there is a sale or a transportation of a product or the service in intrastate. When I say service, that the service is being rendered. The service is being rendered. That either happens intrastate, meaning that's within the state, or territorial, interstate, across state borders, or international commerce that Congress can regulate federal. So when it's intrastate, those rights are limited to the geographical border of the state. But Congress regulates interstate, meaning once you sell or transport your product or you render service across the state lines, now we're in the realm of federal trademark protection. But we'll get there in just a moment. So anytime we talk about use in commerce, we're really talking about you're using in business. You're actually in business. And so that's what use in commerce is. And so here is where people don't understand that if you're not using it and you're not in business, this is how your brand can get stolen before you ever secure trademark rights. Because remember, trademark rights are not created by trademark registration. Okay, so trademark rights are based on use. In the United States, trademark rights are based on use. So if you don't have use, you have no trademark rights. You have to be using it. Now, these are the 5 requirements. It has to be distinct. It has to be placed on a product or service. It has to act as a source identifier. It has to be used in commerce, and it's not likely to be confused with an existing mark. That means there's no existing mark that is likely to be confused. It doesn't mean that it's the same. If it's similar, then it's possible that there can be some confusion. Now, I want you to stand up. Woo! I want you to stand up, okay? Stand up. I want you to stretch out. I want you to shake those legs. I want you to move and wiggle. I know that we are at the end of the day. Some of you got off work. Some of you have been working in your business. Some of you have children. You've been moving around. I want you to stand up and stretch. I know what it's like when you, at the end of the day, ready for bedtime. Stand up and stretch, move and wiggle. All right, y'all stand up and stretch. You did it. You did it. You did it. Okay. All right. All right. All right. So let's get ready for the Beyond TM Trademark Challenge. We have a challenge. Are you ready? Are you ready? Are you ready? All right. Let's get ready for the challenge. All right. So here is the challenge. You're going to have 30 seconds. You're going to have 30 seconds. You're going to have 30 seconds. And here's what you're going to do in those 30 seconds. You are going to find as many items as you can that have the following marks on them. I'm going to show you the marks in just a moment, but you have to find as many items as you can that have the following marks on them. The person who has the most marks wins. Not the most marks wins, not the most items. The person who has the most marks wins. Now, let me give you a clue in. You can probably find a lot of them in your bathroom or kitchen. Okay, so get ready. 30 seconds. Now, at the end of 30 seconds, you're going to take a photo of all of your items and you're going to post it online. You have to use the hashtag BeyondTMWebinar. And you're going to tag my law firm, Legacy Legal CF. Don't worry about remembering that right now. But if you don't have social media, you can still participate. So that came up last time and someone was like, I don't have, they didn't know that they could participate. And so they didn't engage in the challenge. So are you ready? We're going to have 30 seconds. I'm going to get ready to start the timer when we get ready. 30 seconds to find as many items that has the most marks on them, okay? Not that you got to find the most marks, okay? So it doesn't have to be all on one item. Now, get ready. Get set. And go find these marks. TM, SM, R. 30 seconds, all right? You have 20 seconds. 10 seconds left. Do, 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 do. 4, 3, 2, 1. All right, come back, come back, come back with your items. Come back with your items. Stop, stop, stop. Come back with your items. Come and bring your items before you. Don't forget, take a photo. Take a photo. Take a photo of your items. Now, let's find out who our winner is. I want you to count all of the symbols you see on your items. Every TM, every SM, and every RUC counts as one mark. It doesn't matter if it's on one product. Every TM, every SM, and every RUC is one mark. So I want you to count them up. And how many do you have? I want you to drop your answer in the chat. How many do you have? How many do you have? Okay, we got 3. Okay, let's see who has the most. Anybody beat 3? And don't cheat, y'all. We folks of integrity. Don't cheat. Don't cheat. How many you have? Okay, so we got 3. So right now, Angela's in the lead of the challenge. Right now, she's the winner. I don't know how many of y'all have ever did Mario Karts. I used to, you like, ooh, they hit you with the turtle and you spin around. All right, Nakia got 3. All right, so we got a tie. We got a tie for first place. Anybody beat 3? Anybody beat 3? Woo! He said it took 27 seconds to find my glasses. Okay, so every time I do this, I'm gonna learn something. I learn something new. So I'm gonna add next time to the instructions. Make sure y'all find your glasses before I say ready, set, go. Okay, so we're gonna help the folks out who need their glasses. And don't feel no type of way. The other day, I could not find my glasses. It took me probably 10 minutes and I still couldn't find them. I just found my glasses today, right on the counter where I kept looking at them. So I understand. Anybody beat 3? So y'all the only ones that participated. That's it. That's it. Okay. All right. Last time, going once, going twice, going 3 times. All right. That's it. Okay. So here's what I want you to do. Okay. Because I have to verify the 3. I want you to take I hope you took a photo of your items, and I want you to post your photo on Facebook or Instagram now. Do it right now. Post your photo on Facebook or Instagram. And I want you to write this sentence. I took the trademark challenge and got number, and I want you to put your number. So it'll be 3 in this case. I took the trademark challenge and I got 3. And I want you to put the hashtag Beyond TM webinar. And I want you to tag my law firm, Legacy Legal CF. Now, if you don't have social media, and even if you didn't share, but you don't have social media, and maybe you beat 3, I want you to text your name and the number of marks that you got to 530-645-3425. Now you got to add your name because I don't know who you are. Okay, and put your number. All right, so do that right now. Now, what did you win? What did you win? Because I said you have a gift. It's right here on the screen. It's right on the screen. There you go. It's right on the screen. It's right on the screen for you. Take a picture, post it on Facebook or Instagram, and then write, I took the trademark challenge and got 3. And then I want you to put hashtag Beyond TM webinar. And then tag at Legacy Legal CF. The instructions are right here for you. Right there. Okay. So make sure you do that so I can verify. I need to verify it. Now, what did you win? What did you win? We got 2 people tied for 3 plates, first place. So what did you win? What you won is you won a free trademark consultation. You won a free trademark consultation. So make sure you post, make sure you verify. you want a free trademark free trademark consultation. Okay. So you're going to have the next 30 days to schedule your consultation with me. The next 30 days, I'll send you an email before the end of the week. So you will be able to contact me and schedule your consultation. Okay. Now, congratulations to our winners. Congratulations. Okay. So let's jump back in. Okay. So let's talk about the types of trademarks. A trademark can exist with or without a registration. Thank you, Deborah. A trademark can exist with or without trademark registration. And so there are three types of trademarks: common law trademarks, state registered trademarks, and federal registered trademarks. There are three types: common law, state, and federal. Now, I see a text come in. I'll look at that once the webinar is over. But if you have social media, please post it on social media as well. Okay. So common law trademarks are essentially trademarks that exist under common law. There's trademark law, they haven't registered, but because they met the Fab Five, they are a common law trademark. Boom, there's a trademark. Next, you have a state registered trademark. These are trademarks that are registered at the state level. And then you have federal registered trademarks, which are registered at the federal level, which is with the USPTO office. Now, understand this: the protection of each of these types of trademarks are limited by geographical boundaries. So if you have a federal trademark, you have protection all over the US. If you have a state trademark, registered trademark, you are limited to protection within that state. Now, common law trademarks are limited to protection only in the states they actually use the mark. So if you're not using it in all 50 states, I believe we still got 50 states, y'all. I haven't checked it, but I hope we still have 50 states or territories. Look, just all of the United States and however many they add or whatever happens, okay? If you're not using it in all of those, then your trademark rights are limited to only where you actually use it, because trademark rights are based on use. And so federal registered trademarks give you exclusive rights and protection all in the U.S. borders and territories. So some symbols that you see on the side: TMSMR. Let me clarify this, because I had a question this week that really brought some confusion to that person as they were trying to understand what SM stood for. SM does not stand for a state trademark. SM stands for service mark. A TM is for a trademark. So products use TM if they're unregistered. SM is for service mark. So if you have a service, SM can be used to reflect that you have an unregistered trademark, an unregistered trademark for services. Now, TM and SM are used. This is for non-federal registered trademark. So if you don't have a federal trademark, then you can only use TM or SM. You don't have to, but you can. Now, if you have a federal registered trademark, meaning your trademark has been approved by the USPTO, you can legally use the R symbol. So going beyond TM, going beyond an unregistered trademark. A TM, again, is a symbol for unregistered trademarks. And I talked about this already, but unregistered trademarks can be protected as a trademark, but their reach of protection is only limited to the geographical regions where the mark is used. And you can also use TM for state registered trademarks. Now, I came up with this concept because I was trying to think of a way to properly teach this to, my folks who are in business, but you didn't go to law school. And what came up was the road to R. You are here because you are probably considering getting on the road to R, or you already are on that road. And so on Route 703, which is the the area code for Virginia, where the USPT office is, there is a road to get there. There is a process. So I want you to think about this process as a road trip, okay? Now, going beyond TM is taking the journey from TM, unregistered trademark, to R, a registered trademark, by filing a federal trademark application for nationwide exclusive trademark rights. So where you start is where TM is, you have to brand it right. So you have learned so far through this webinar, if you get it wrong in the branding, you will never make it to your destination of trademark registration. But you got to get in the car first. You got to get in the car. You got to get in the car. And the car represents your brand, but also your application. You got to get in the car. You got to journey there. And so some applications never make it to their destination R, and others get stopped and derailed along the way, and they never go beyond TM. So the journey actually begins at the USPTO. This is where we start. So the road to R, this is the overview of the federal trademark registration process. Now, again, I want you to think about a road. First and foremost, before you ever go on a road trip, hopefully you do a safety inspection check. Why? We want to make sure that the engine light is not on. We want to make sure that the gas gauge is not, faulty, and got gas in the tank. We want to make sure that the oil is good, right? We usually take it to the mechanic or top it off with oil. Why? Because we don't want to have a breakdown on the way to our destination. And so we may fill up the tire with airs, check it, just make sure everything is good before we get on the road. So we do a safety inspection check first. And on the trademark side, that's called conducting a trademark legal clearance search. This is where we do a search of what is out there in the business world to identify potential roadblocks to your trademark application. This is also where we identify potential infringers, whether your brand might infringe on theirs, likelihood of confusion, or their brand may actually be a block in your trademark registration process. So a trademark legal clearance search is where we do the safety inspection check, because we don't want you spending a whole lot of money to get a trademark only to find out you can't get the rights. The government is not going to refund you your money. Okay. And so I just had a conversation with a client last week that this actually happened. They tried to DIY their own trademark application. I know it's easy to try to want to save money. And what happened is their application said, no, there's another company, there's another mark here. There's likelihood of confusion. And so it blocked her trademark application. This is why we do a inspection check, because we could identify the potential mark. And so that is the first step. Now, there are two types of trademark legal clearance search. The first is a preliminary, and the second is comprehensive. A preliminary search is where the first search, where we usually just search the USPTO database. We see what is actually there. The second search, comprehensive, is where we search outside of the database, because you can have state registered trademarks, you have business names, you have people on the internet, social media. And so we want to see what is all out there. Now, once we get past the inspection check, it's time to get on the road. It's time to get on the road. And we have to choose the vehicle that we will use on the road to R. And so there are two types of vehicles you would choose. Here's the thing, it's already chosen for you. And so the first choice in your vehicle depends on whether you are currently using your mark in business or you're not using it, but you intend to use it. If you are currently using your mark in business, our stop number one, choosing our car, you are filing what's called a 1A trademark application. It's current use. Your car has been selected for you. But if you're not using your mark yet in business, let's say that you are about to launch, whether it's your new business or a new product or service, or you're in a rebrand stage, and you want to protect it, Then you would file a 1B application, which is intent to use. This car, again, is already selected for you. So you don't have to make a decision here. You just have to know, am I using it or not using it? If you're using it, it's 1A. If you're not, it's 1B. So now that we have chosen the car, the vehicle that we're going to get on the road with, now we have to file the trademark application. This is what starts the process. Once you file the application, now we get to stop 2. Your application is assigned to what's called an examining attorney. This is the attorney at the USPTO office that is actually going to review your application. And so when they review your application, they're looking to see if there's anything wrong with it. They're looking to see if it's good to go. They're doing an evaluation of your mark and what you place in your application. And so the estimated time for this stop is anywhere between 6 to 12 months, and it could be greater. It just depends. This is a time where we're just waiting for the application to be assigned to an examining attorney. We're just waiting. Now, once it is assigned to the attorney and they begin to review it, now they may issue what is called an office action. So now we move to stop 3. We got movement here. At stop 3, an office action is an official letter from the examining attorney that says, there's something wrong with your application that you need to fix. You need to respond to this letter and communicate with us why either your application should go forward, why there's no issue here. You need to respond to what they have placed in the application. And so if you don't respond correctly, then what happens is that your road trip is over and you would have to go home. I don't know how many of you saw Sister Sister growing up. It used to be one of my favorite shows. And the next door neighbor, Roger, would come over. And what they say, go home, Roger. And so this is what happens. If you don't respond to an office action or you fail to respond within the 3-month time frame or don't request an extension, this is where they say, go home, Roger. And you have to go home, which means that either you start the process over or there's no trademark for you. Okay. And so this is where I don't want you to understand that a response to an office action is not just writing a letter to your best friend. This is an official legal brief with citations. You are making legal arguments in a response. Now, if you pass inspection from the examining attorney, meaning that you respond correctly, you respond within the time frame of 3 months, you go on to the next step. So I want you to think about this like border control. I don't know how many of you have ever crossed the border from the US to Canada or Canada to the US. But when you get to the border control, what happens? They look at your documents, they inspect your vehicle, they're inspecting to determine whether or not you can cross the border. Now, if something is wrong, what do? They tell you go over to the side. Why? Because they're going to do further investigation. But if everything is good, what they're going to do, they're going to hand you back your documents and wave you through. This is what happens at stop 3. The examining attorney is like the border control. You are either going to say, hey, we got to pull you over. There's an office action. We got to pull you over and we got to expect some more, which means you got to respond. If you don't pass that, border control is not going to let you pass. But if it's all good, they may let you get back on the road. Now, if you are at the gate of the border control and they don't have any issues, sometimes you don't get an office action. They say all is good, go on ahead. The same is true at this stage. Now, once you get past that stage, next, essentially what they said is that your trademark is good for a registration. It's good for approval. But now we have to publish it in the Gazette for 30 days. We have to give other business owners and other people who have rights an opportunity to oppose your application. So I explained to you like this. One of my favorite shows, y'all, is A Different World. Yep. One of my favorite shows is A Different World. And one of my favorite episodes is the episode when Dwayne showed up at the wedding of Whitley, when Whitley was about to get married. And what did he do? He objected. He said, And Whitley left that altar with Dwayne, didn't she? And if you haven't seen that show, I apologize that you missed out on one of a classic. It's still a classic. It's still playing today. It's a classic. Now, the objection to the marriage is similar to the opposition to your trademark application. The USPTO already said this can go ahead, but somebody now is objecting and saying, this, if you let this trademark application be approved, it can affect my trademark rights. And so if they oppose your application, this is what I say is a possible pit stop. So the opposition notice, once they give it, now it's like a detour. It moves you out of the USPTO trademark process, and now you got to go fight. Now you got to litigate. Now you are in a TTAB hearing. Now you got to win this legal battle. If you don't win this legal battle, it's a go home, Roger. That's it for you. It's the end of the road. And so you have to fight, and you have to show why your mark can be approved and why it does not infringe on their rights, why it won't affect them. Now, if you win, you move on to the next stop. Now, remember, when I started, I said you have to choose your vehicle. Either you're going to have option A, you're currently using it, or option B, you intend to use it. And if you remember, I told you that trademark registration doesn't give you a trademark. You have to have a trademark before you apply for trademark registration, which means if you have a 1B application, meaning you're not using it, but you intend to use it, and you make it through the TTAB hearing, you have another stop that you have. This is a stop only for 1B applicants. This is a stop only for those who have not started using their mark in business by the time when they apply. And so what happens is the USPTO will issue what's called a notice of allowance. And so what they're saying is now it's time for you to submit proof of how you're using your mark in business. You have to show us you are using it. You got to show us you met the Fab Five. You have to show us you have a trademark before we approve your trademark. And so you have to respond with a statement of use. And the estimated response time is 6 months. Now, you can request extensions of an additional 6 months, but you have 6 months to show proof of how you are using your mark in business. And if you don't, it's a go home, Roger, because you don't have a trademark. Now, if you already you were already using your mark in business, you made it past the opposition stage, or you made it past the publication period and nobody opposed your application, or you're a 1B applicant, you intended to use, you made it past the publication and you got to the notice of allowance and they said, we accept your proof of how you're using your business, you're good to go. Now you reach your destination of R. You have a federal registered trademark. It has been approved. Congratulations. But here's the thing that you have to remember is just because you reached your destination of R, there are still future stops. It is not over. And so once you get your federal trademark, you have to show you are still using your mark in business. You have to file what's called maintenance or renewal filings with the USPTO. And so the first filing is due between year 5 and 6 after your trademark registration has been approved. So between year 5 and 6, you're going to have to submit your documents of how you're still using it in business. Then between year 9 and 10, you're going to have to show it again. So they want to make sure that you're actually still using this mark, or if not, it's going to get canceled. That's a go home, Roger. That's it. Now, after you get past that first 10 years, it's every 10 years because trademark rights are based on use. If you stop using it, you lose the rights. So you have to keep showing you're using it in business. So your total trip time on the road to R can be between 12 months and 18 months. It really just depends. Because if you get a notice of opposition and you have to fight, that extends the time. If you get an office action, that extends the time. And so there are different parts of the process where someone else's journey may be quicker than yours, and your journey may be longer just because certain things popped up. Now, what is the application fee? The application fee is $350 per application. That is per mark for one class. Every additional class, you'll pay an additional $350. Okay. Now, if you have a 1B application, you'll pay the $350, but you also have to pay another fee when you get ready to submit your statement of use, your proof of how you use your mark in business. So you'll have to pay that fee as well. But at that point, you have made it to your destination. All right. So the benefits of a federal registered trademark: exclusive nationwide rights to use your trademark in the US in the registered classes. You have protection, remember, in that grocery aisle, that registered class. Establish a legal ownership and strong foundation for legal action. So when somebody is infringing on your brand, when you have a federal trademark, it establishes you as the owner, which means you have more leverage to go and enforce your rights and possibly shut them down. You also have brand recognition and trust amongst consumers and clients. So when they see the R, this shows that this is a reputable business. You're taking business serious. Also, it's a creation of a valuable business asset that can increase the value of your business, and it can be used as collateral. It can be used as collateral because a trademark is a part of intellectual property. Now, my definition of intellectual property is it's the real estate of the mind. Think about real estate. What can you do with real estate? You can do the same with intellectual property, a trademark. Another benefit is that registration may be used to register your trademark in other countries. So when you get trademark registration in the US, that's under US law, but you don't have protection in other countries because trademark law is different in other countries. So other countries, they may be right, the first to file gets the trademark rights, not the first to use. In the US, it's the first to use. Somewhere else may be the first to file. So if you want to secure your rights in another country, you have to file in that country. But a US trademark could be used to help you establish your rights in another country and maybe fast track your application. And also another benefit is you have the right to use the R symbol. Okay, so trademark with legacy, and then we're going to open up with questions. So get ready with your questions. Trademark with legacy. Let us guide you safely to your destination. And so I just want to share with you what we offer. So we offer a launch with peace of mind consultation. So for our winners of our challenge, this is what you get. You get a 30-minute trademark legal consultation. You get a preliminary trademark legal clearance search, that inspection check before you get on the road. We do a preliminary check of the USPTO database to see what's out there that can potentially block your trademark application, but also be a possible flag for trademark infringement, meaning we're trying to avoid lawsuits as well. We also evaluate the strength of your mark. And so this is a really good stage when we talk about the launch with peace of mind consultation, because at this stage, if your mark is not good, if we find a conflict, you get to rebrand before you launch. And so that saves you money and a lot of time and headache, because for some of you who, you spent 5 figures, how much money you spent in business, whatever you spent on your brand, you don't want to have to waste that money launching, or you don't want to invest in applying for a trademark that you can never own. And so this consultation is where we make sure that we are positioning you for the best chance of success in getting your trademark approved. We can't guarantee that, but we're positioning you. And so this is a preliminary assessment of trademark protection and registration. We also do a risk assessment and analysis to determine rebrand or launch. So this is where we tell you, you might want to rebrand, or it looks like there's a green flag of let's go ahead. And when you trademark with us, the fee that you pay for your consultation can be applied to your trademark registration package as long as you move forward within 30 days. So the investment for this consultation is $150. Our trademark process always starts with a consultation. Why pay thousands of dollars when you can start here? And then we can tell you rebrand or move forward. So this is the consultation. It is available if you're trying to identify if you have a good brand. Should you launch this? If you are like, I want to know what's out there before I move forward. I want to avoid trademark infringement, cease and desist. This consultation is good for you to start. Now, if you're like, I'm ready to move forward, after our consultation, we have our standard trademark package. This includes a comprehensive legal search. So we go deeper. So remember, the preliminary search, the knockout search, is just of the USPTO database. But the comprehensive search is the entire US. We're looking at the US, the federal level USPTO. We're looking at the states. We're looking at state registration, trademark registration, and their business entity registration. We're looking at what's on the internet. We're looking at what's on social media. We are looking at everything. And then if the search comes back and it shows we got a potential issue here, and we may need to make some changes, you also get a complimentary backup search if the first search fails, okay? So if we have to do another one, we got an option to do that. After we get the report back, I will write and issue to you what's called an opinion letter. This is risk analysis. This is me looking at the entire results and then telling you whether or not you should move forward. And I use it like a stoplight. It's either green. I use green, yellow, orange, or red to say stop, orange, maybe, yellow, proceed with caution, green, go ahead. But the choice is always yours, okay? So we just analyze the risk. This also, what'll happen is identify those potential marks that may pop up when the USPTO examining attorney does their examination. So we already know what we have to fight against, and that we evaluate whether or not we can win. Again, cannot guarantee, but there's an evaluation. Can we win this? There's a chance. It also includes a 30-minute consultation. So we'll talk about the results. And then when you're ready to move forward, the trademark application fee is included. So it's the filing fee for one mark and one class. And if you want to add additional classes or marks, that is not included, but you can add that on for the additional fees. Now, also in our package is the office action responses. So we respond to all office actions. Now, you may see other packages and they'll say, oh, you'll pay $500 for office actions. Please do not be tricked, okay? Please do not be tricked, because if it's $500 per office action and you get 3 office actions, you now have spent $1,500 more than what you intended. The price may seem low, but make sure you know what's included, right? Those hidden traps. Another thing that you receive is your trademark registration certificate. And we also give you the maintaining your trademark after registration guide. This is how you maintain your trademark rights. This is how you make sure you don't lose them, because it is possible to lose your trademark rights. Xerox is an example of a company who has a trademark, but they were at risk of losing their rights. Why? Because everyone started calling every copy machine a Xerox machine. So they had to start changing that so the Xerox name did not become generic. Everybody's using it, right? Again, standing out. So this is what's included in our trademark package. Now, fees. Let's talk about the money. And so for everything that we include in our package, the investment is $2,500. Now, I'm saying investment because it is an investment. You can risk it. You can try to do it yourself, and you can end up getting your trademark blocked, canceled, and that has happened. I'm fixing those issues now, okay? Or you can just hire someone who can help you safely on your destination. So the investment for one mark in one class is $2,500. But I don't charge that upfront. I'm a business owner myself. I know that you need to know what the fee is before you get started, but also it depends on where you are in your business. And so I work with my clients. One thing my clients know in legacy legal, I don't nickel and dime you. Okay, I will work with you. We can figure this thing out if you truly want to trademark with legacy. And so I say that initially, the initial fee to get started is $1,500. That breaks, I bill, how I bill is I bill in segments. So the different stage of our process is where I bill. So you don't pay $1,500 upfront, okay? You pay a different fee. You probably pay about half of that, depending if you do the trademark registration within 30 days. That $150 for the consultation will be applied. So you won't pay $2,500. You'll end up paying $2,350 because we have reduced that balance. So you pay for stage one. Once we find out we're good to go to stage two, you'll pay for that stage. Both of those stages together are about $1,500. That's why I say you want to have that set aside. Now, the rest of the balance is paid on a payment plan. So we don't start billing you until 3 months after the trademark application has been filed. Why? Because we're going to be sitting around and you already made an investment. So now we'll just put you on the payment plan to pay the rest off. All right. So by you being here, I have some gifts for you. Okay. And even if you're watching the replay, because we had a significant amount of people actually register, you can take advantage of these gifts. So if you decide to move forward with a trademark registration by June 21st, you're not going to pay $2,500. You can get it for $2,000. So we'll knock off $500. And if you do the trademark consultation and apply it, then that knocks off another $150. If you move forward by August 1st, then we'll knock off $300. So you'll get it for $2,200. These are my gifts to you. Now, to get started, all you have to do is schedule a discovery call. That's the first step. It is a free call. This is just where it's just an introduction. And after that, you'll be able to book your trademark consultation. So you can schedule a call at trademarkwithlegacy.com. Trademarkwithlegacy.com. Okay, now let me open it up to questions. Are there any questions? You can drop them in the chat. Any questions about the content? Any questions about the trademarking with legacy, our packages? Are there any questions before we move on to our bonus material? Because we still have some bonus material to cover. Any questions? Any questions? All right. And if you have a question and you're typing it out, you can put a 1 in the chat just so I know your question is coming. Okay. So we have a question. When you talk about TM within state lines, how does that work for online? So essentially, if you are selling online, then where are you selling? Because once you go across state borders, you're not limited just within your state anymore. Why have you gone beyond that? So your rights are being established in the places where you actually do business, even if you're on the internet. That's how that works. Let me ask some questions that were actually answer questions that were submitted with registration. Angela and Marilyn asked, should a small business focus much on brand? I hope that through this presentation, you have learned, yes, you should focus on it if you want to protect your brand. So if you don't focus on branding and you brand a product, a service, you brand a conference, you brand a podcast, you brand a business name, and it literally infringes on someone else's trademark rights because you're not focused on trademarks and or focus on branding, then what happens is this. They can send you a cease and desist, or they can sue you for trademark infringement. And so when we talk about focusing on brand, we're really talking about what I would say is asset protection and wealth preservation. Lawsuits are expensive. Rebrands are expensive. And so if you're not at that stage where you have money to give away, I don't ever want to be at the stage where I just have money to give away. I want to keep my money. I don't, even if I'm at the $1 million mark, I want to keep my money. then yes, you want to focus on branding, because when you brand it, when you name it, now you have to think about, are you, so here's how I break it down. When I talked about the trademark legal clearance search, the first search, the preliminary search, is asking, can I use this name legally? So when we do the search, we're a trademark legal clearance search, we're asking, can you use this name legally? That means, can you use it without infringing on someone else's brand? The second question is, can you trademark it? So this is asking, do you have the rights to trademark? Now, if you choose a brand that it doesn't fall under trademark protection, doesn't fall under trademark law, it doesn't meet the FAT5 requirements, it doesn't matter if you register or not, somebody else can use the same name. And so now what's happening is, if they're doing the same business as you, they're using the same name, it's possible that the profit and the clients or customers that were meant for your business is being diverted. That's why branding matters. Okay, let me go to the chat. If you're selling digital tools services that would qualify as a SM and ideally lead to a federal R, correct? If you're selling digital tools, so if you're selling digital products, that's a product. If you're selling services, that's a SM, that's services. But ideally, yes, it would. If you actually apply and get approved, then you can have a federal trademark. The next question you have, so does that still mean only the state you've actually sold in? Yes. Yes. You don't have exclusive rights all over the US. It's just those states. That's why it's important to go beyond TM. So if someone in another state that you never sold in is using your brand, you don't have protection there. You don't have trademark rights there. All right. So next question we have is from Nakia in Maryland. Let me ask the other question. Should the LLC, brand name, or both be trademarked? It depends on what needs to be protected most. So I am a business strategist. I'm a strategist. So I'm not just, oh, let's trademark. No, let's talk about the reality. What's your budget? Let's talk about what are you actually trying to protect. One thing about my law firm is I focus on vision. I don't believe that your legal strategy should be divorced from your business strategy in your business, because we want to make sure your legal strategy grows with you. So if you are, and I'm gonna share a little bit more about some things, some mistakes you want to avoid in just a moment, in our bonus materials. So do you need to protect the business name or the brand name? And so oftentimes, if you're trying to decide if you are really doing business under the brand name is what you should protect. But if the brand name is the same as the business name, then protect the brand name. You don't need the LLC protected. You know how when you use your business name, you put the LLC behind it. That's not what you need protected. If the brand name is the same as the main LLC name, then the brand name will protect both. That's what you're protecting. Okay. And the other question that you had was, how do we protect our brand when working with individuals to brand and market materials like creating logos, websites, etc.? I'm going to answer your question when we get into the bonus material. All right. So if those are the questions, okay. So let's move on to our bonus material. Okay. So here's the question. When should I trademark? When should I trademark? So this is a common question to ask. This is the common question that comes up, well, when do I do it? And you will hear different answers depending on who you ask. And so this is, my answer is, it depends. It really depends. I filed my own trademarks. Some I filed before I used it because I knew I needed to protect it. And others I didn't file until 3 years later. It just depends, okay? And so this is kind of like, does the chicken come before the egg, or does the egg come before the chicken? Which one comes first? And so when we talk about trademark timing, it depends on your business's unique needs and circumstances. And so you can trademark before you launch if you're like, I really need to protect this, or you can trademark after you launch. Now, remember, trademark rights are based on use. So if you decide to trademark after you launch and then there's brand infringement, it's possible if somebody decides to register a trademark that's for your brand name or similar, then that means that now you have to be the one in their process to object at the right stage. But how many of you are actually monitoring trademarks that are being registered? It might fly past your radar. So this is where working with an attorney is important, but these are your options. Okay. Now, again, practical business advice. You heard me say I have other businesses. I have a contract template company called 180 Contracts. I did not register that trademark until we were around for 3 years. That's when I started. That's just not where I was. I needed to get the company up and running and get sales in. I needed to see if it was viable. All right. So remember again, trademarks are based on proper use. You have to properly use it, and distinctiveness, how distinct it is. And you can lose your trademark rights. I mentioned that when I talked about Xerox. Now, here are some mistakes that prevent you from protecting your brand with trademarks. These are mistakes you don't want to do. The first is branding weak marks. There is no trademark protection for weak marks. The second is improper use of your marks. If you use your mark in the wrong way, you don't have trademark rights. The other is revealing your brand before you protect it. So your question in the key is about how do we protect our brand? Well, it depends on what stage you are in. If you are in the branding stage, and I didn't add this slide in here, but if you are in the branding stage, there is no trademark protection in the branding stage. None. And so what happens is in the branding stage, you're vulnerable. And especially if you're working with someone that's branding for you and doing marketing. So what you want to do is you want to have a contract in place. Okay. You also want to be mindful because somebody can literally swoop in and steal your brand when you're in the branding stage and you haven't done the Fab Five to actually start using it. And so here's the thing. I'll share with you this. When I was in the branding stage, I did a rebrand. So it's not just branding, it's also a rebrand. I did a rebrand for 180 Contracts because when I started years ago, I started in Canva, y'all. I had a Canva logo. And so I got it to the stage where I'm like, okay, I'm generating revenue, sales are coming in. I think it's time to hire an actual like professional at branding, like actually have this look legit. And so I was working with a branding person, and they did the first design concepts of my logos. When I got it back, I wasn't really excited about it, except one grabbed my attention. It was like a 180, and it had like the zero was a loop, but in the zero, there were like the bar charts that go up, the bar charts that go up. Now, here's the thing. When I saw it, I immediately thought of another business. There's a Facebook group I'm in, and their logo has the bar charts to go up. Now, my company is 180 Contracts. It's not about degrees. It's about direction. So it's like, this is really not on brand. But in that branding process, if I did not catch that was potential trademark infringement, I could have launched that and then been in trouble. I could have launched and then been in trouble. So I'm going to give you a tip really quick. I know I haven't gotten to the brand protection tips yet, but I'm going to give you a tip really quick. What you can do in that stage is that you can actually take that image of the logo and run it through Google reverse image search or image search. And it's going to show you all of the potential images or logos that look exactly like that. And then that way you can look. And remember, when you remember our trademark grocery store in the aisles, when we're talking about likelihood of confusion, now you can identify, do they sell the same or similar types of products or services? And you can actually just Google what the trademark classes are so that you know what aisle you're in and what is all in that aisle. And that's how you narrow your search. I know I'm not teaching DIY, but that's something you do in the branding stage. Because if you get it wrong in the branding stage, by the time you get to a trademark lawyer like me, there's nothing we can do but tell you rebrand. Okay. So I avoided that. And then she came back with new designs, and I said, that's it. That one is it. There should be no issue with that design. All right. So mistakes you want to avoid. The last one is registering for a federal trademark before you lock in your brand. The reality is many of us start our business and we're not locked in yet, right? We're trying to fill the market out, and we're trying to see, does this resonate with our target client base? Does this resonate in the market? And so sometimes we may rebrand. And so you don't want to file for a trademark if you're not locked in because it's a waste of money. And so only the mark that you register, exactly how you register it, is protected. So if you try to register the design for the logo, the color, the style, there's no future changes to that logo. So if you file for a trademark and then you change it later, you essentially have lost your trademark rights. Why? Because you stopped using that mark. So you want to be mindful of that. All right. Another mistake is failing to enforce your trademark rights. So you don't want to have people out here that are using a similar mark or the same, and you're not enforcing your mark, or you may use your mark, lose your trademark rights because now your brand that was standing out and distinct, that it was not confused anymore. Now there might be confusion in the marketplace, and you have to protect it, or you might lose your rights because it became generic. All right. Brand protection strategies that go beyond trademarks. It goes beyond trademarks. So we're not talking about trademarks anymore. We're talking about the other, because many people think brand protection is just trademarks. No, it's not. Remember, I said that in the branding stage, there is no trademark protection. So how do you protect your brand at that stage? With a contract. With a contract. With a contract, and it has to have specific language in it. So you can have a NDA, you can have an NDA clause with an existing contract, especially if you want to put additional protections to make sure that if they use your brand in that stage, that you can get it back. Because under contract law, you're not, if you don't have certain language in there, you can't get your trademark rights back. You just have an option to recover under contract law. But the reality is that, you know, depending on what you put in there, liquidated damages, you actually could possibly bankrupt that company if they steal your brand. So brand protection strategies. Look, we came to knock out folks if we need to protect our brand. Other things that you can put in there to protect your brand in contracts is licensing. So if you hire a marketing person, a social media marketing, or any type of person that's marketing for you, and they're using your brand, you can put in a license for it. You can use my brand for these particular reasons. A license puts some boundaries around the use of it. Same thing if you are doing affiliate marketing, you're hiring people to market for you, you have employees, they also may have to use your brand, your logo, the name. And so you want to have a license for them to do it, but you also want to have restrictions on use. This way that your brand stays distinct. Remember, your brand is not just the mark itself, it's also the reputation. So you want to protect your reputation. Y'all, I can't put this in here, but I was on Instagram one night and I saw this mascot, and he was just doing a sexy little dance outside. And I said, you know what? I don't think that the company wants that to reflect their reputation. So you want to put some restrictions in your contract about what they can and can't not do, not just with your brand, but also with their actions, because they represent you too. Okay. Another way to protect your brand is with copyrights. So copyrights have a longer protection possibly than trademarks, because copyrights are based on the moment it is fixed in a tangible medium of expression. And so copyrights can live 70 plus years beyond the life of the creator or beyond the life of the author. And so your logo can be protected under copyright law if you copyright law. So just like trademarks, copyrights exist the moment it meets the criteria. But if you want to be able to protect and enforce and sue, you have to register it. Another way to protect your trademark, your mark beyond trademarks is well-written policies and licenses. So you want to include guidelines, restrictions, as well as notices of brand ownership in your policies and licenses on your website and in your products and related services. You've probably seen it. You can go into your bathroom, your kitchen, and you'll see that this mark is a registered trademark of this company. Okay, I saw it. I don't have it with me, but it's on one of my vitamin bottles. I have it, and you'll see the example of it. Look, I hope after this class, you will start to see trademarks everywhere you go and just start paying attention to it. And you'll start noticing, oh, this is how they do it. And the other way that you can protect your brand beyond trademarks is enforcement and monitoring. And so you want to monitor for infringement and for your rights. And you can do that with a cease and desist letter, oppose new applications. That's the objection example I gave at the wedding. And you can potential to cancel trademark registrations. So if you have a trademark, let's say you file your trademark and there is a trademark that is literally blocking your application, but they haven't been using their mark, you can petition to cancel their mark and clear the way for your trademark to be registered. There are different types of strategies in this process. So it's not over until it's over. And again, I just want to leave you with this. These are your options. You can choose the Launch with Peace of Mind consultation. Even if you're not ready to trademark, this is available to you. So you can get some consultation on your brand, the strength of your brand, and you can just schedule a call with Trademark with Legacy. And then if you're ready to trademark, this is what you have. And you have gifts if you move forward by June 21st. We knock off $500, or August 1st, 2020. Please don't be scared of the price. Just come in, just ask, and we can work with you, okay? Because if you never ask, the answer is no. So any questions about what we talked about? And for everybody who is here, I have a gift for you. So I know we have our winners, but I also have a gift for you. I didn't leave you out. I wrote a quick resource called 4 Tips to Create a Trademark Ready Brand. Okay. And it covers some of the information that we had tonight, because y'all, are you really going to remember everything we talked about in 2 hours? Probably not. And so these are what we talked about. So you can download that. You can take a screenshot of this and download it. Now, if you don't have questions or you're about to ask questions, I want you to do me just a brief favor being here. I want you to write in the chat box. Tell me what's one takeaway for you? Did you enjoy this webinar? Would you recommend it to somebody else? How was this webinar? How did I do? What's one thing that stood out to you? What are you going to implement? I want you to just take time and write that in the chat. And if you don't want everybody to see it, you can just send it directly to me. But share, tell me, what did this do? Did this help you understand trademarks better? Did you walk away understanding trademarks better than when you started this webinar? Or is it the same? Is there anything I can improve? Just tell me very briefly. This helps me. Oh, I just saw your comment. A lawyer told you, don't do a trademark until you generated at least 10K in revenue. No, that's no. 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 It's not based on revenue, because again, I have a trademark registration pending for my own self, and I'm just starting to use it. So I'm using it now because I registered the trademark, but I registered before I used. And so you can register before you even make 10K. My thing is, be locked into your brand. Be locked in, okay? Because I don't like wasting money, and I don't want my clients or anyone else wasting money too. All right, so we have very informative. This was completely full of amazing information. I can't believe all of the half truths, I believe. Thank you so much. Still leaving full. I love that. I absolutely love that. This was awesome. Certainly clarified some areas we discussed previously. Better understanding your trade. This is what I love. I want you to walk away better understanding it, because again, before you ever get to me, you either have a trademark or you don't. And so this is how we make sure that you are better positioned, that when you go into the branding process and you're coming up with names. Look, I do it myself. I've been asking ChatGPT, what do you think about this name from a branding and marketing perspective, right? But I'm also thinking about, okay, what am I going to use it for, the product or service? And then I can go and see, is there a conflict? Can I really use this? Before I launch, I'm trying to figure out, can I use this so I avoid trademark infringement? Okay, we have informative, relatable entertainment. The workshop confirmed that my overthinking was to prevent wasted time and money, considering consultation, maybe a 90-minute session next time. Look, come on in, get your just book a discovery call. We can talk on the call. The call is free. You don't pay anything. Okay. One thing about my law firm, we are flat fee. So you will always know what you're going to pay before you pay. I'm a business owner too. I don't want hidden calls. Y'all know, y'all know how some attorneys, they have billable hours. And so you do a call and the next thing you know, you're getting an invoice. We not doing no sneak attacks, okay? Someone said, I have a friend wanting to watch this. How can I connect her with you for the replay? You can, let me go to this slide. In the end, you can have her send an email to me. You can have her send an email to me at contact@legacylegalconsult.com. So if you came in late, you missed the beginning, I shared this slide. You can take a screenshot of this so you can keep it and you can reach out. Now, again, I thank you for sharing what you put in the chat. If you can, screenshot that, I want you to scan the QR code and you can leave a review there too. And if you're watching the replay, scan the QR code and leave a review. And so I thank you so much for coming to the webinar, spending 2 hours with me. I know it's a Wednesday night. You can be anywhere, but I hope that your investment of time reaps many, many benefits and that you walked away with more than what you expected to get. And for those of you who you want to book a consultation, those of you who you're like, I'm ready to trademark, or you know someone who's looking for a trademark attorney, you can go to trademarkwithlegacy.com. And as you see, our main website is just legacylegalconsult.com. The trademark website just goes straight to our trademark services page, but you just book a free discovery call. The call is where we just talk and see if we are a good fit before we move forward. All right, so that's all for this webinar. Thank you so much. Congratulations to our winners. You will receive an email from me tomorrow, just letting you know what's the next steps to get started and to book your free consultation gift. And for everyone else, I have a gift for you too. Make sure you download your 4 tips to create a trademark ready brand. And you can get that at bit.ly/ all lowercase trademark ready brand. That's my gift to you for showing up, being here, participating. Now, I was going to do it, but I'm not. I was going to do something, but I'm not. Okay, I'm going to stop right there. For those of you who you know someone, I'm going to be doing this webinar again. So the same place where you went to register, I'll be doing it again. Okay, so it'll be happening again, and they can go to the same link to register. That information will be up by the end of the week for the next Beyond TM, protecting your brand with trademarks. And just to let you know, there's some information tonight that I changed. I added some new things, and so you never know what's going to be in here at all. Thank you, Angela. That's actually one of my trademarks that I registered. And maybe I'll share with you. It doesn't mean what people think it means. But guys, that is it. I'm going to shut down the recording of the webinar. For those of you who want to stay around, maybe you have additional questions, I'll stay for a little while and then definitely answer your questions. So again, thank you for those of you watching the replay. It'll be up for 2 weeks. After that, it's going to come down and you can just register for the next one.